Swayam Prabha. Digital India. Educated India.
Yogah Karmasu Kaushalam.
Welcome to all the students. The insolvency space is extremely fertile, especially in a market economy. It acquires richness, depth and maturity with every transaction. The insolvency regime in India is no exception. The Insolvency and Bankruptcy Code 2016 has witnessed 5 legislative interventions since its enactment to strengthen the process and further its objectives in sync with the emerging market realities. So, this session will help to understand theoretical as well as the practical aspects of Insolvency and Bankruptcy Code, which was enacted recently in 2016. So, let us discuss. We initially start with the introduction on IBC, what is Insolvency and Bankruptcy Code. So, the Insolvency and Bankruptcy Code 2016 is the umbrella legislation for insolvency resolution of all entities in India, both corporates and individuals. The provisions relating to insolvency and liquidation of corporate persons came into force on December 1st, 2016, while those of insolvency, resolution and bankruptcy of the personal guarantors to the corporate debtor came into effect on 1st of December 2019. The aim of codifying insolvency law is to provide for greater coherence in law and facilitate the application of consistent and lucid provision to different stakeholders affected by business failure or the inability to pay the debt. The Insolvency and Bankruptcy was enacted as a critical building block of India's progression to a mature market economy. It addresses the growing need for a comprehensive law that would be effective in resolving the insolvency of debtors, maximizing the value of the assets available for creditors and easing the closure of unviable businesses. A strong insolvency regime serves two purposes. First, it saves businesses that are viable, and second, facilitates the exit of those that are not. The Insolvency and Bankruptcy Code 2016 has been designed to create such a regime in India. Before the enactment of insolvency, India neither had an efficient rescue mechanism nor a satisfactory exit route for businesses. So, the IBC offers a market directed time bound mechanism to resolve insolvency wherever possible or exit wherever required. The IBC deals with the reorganization of insolvency resolution of a corporate debtor, partnership firm and also with the individuals. A corporate debtor is a corporate person that has defaulted on paying its debts. The IBC also provides an exit mechanism for a corporate person that has not defaulted through a voluntary liquidation process. The provisions of IBC related to the corporate persons came into effect from, as rightly said, initially on December 1st, 2016, except for personal guarantors to the CDs. The IBC provisions for insolvency and bankruptcy of partnership firms and individuals are not in force yet. Under the IBC, the rescue mechanism for a CD is achieved through a corporate insolvency resolution process, while the exit mechanism is dealt with through a liquidation process. To reduce the delays and the transaction cost and increase efficiency in those processes, the IBC also envisages an associated institutional infrastructure and creates a new regulatory ecosystem. The efficient working of this institutional infrastructure is critical to achieve the objectives of the Insolvency and Bankruptcy Code. The outbreak of novel coronavirus, that is COVID-19, has resulted in uncertainty for individuals and businesses alike. To minimize this impact of this crisis of COVID, on June 5th, 2020, the President of India promulgated the Insolvency and Bankruptcy Code Amendment Ordinance 2020, which was subsequently replaced by the Insolvency and Bankruptcy Code Second Amendment 2020, which was further notified on 23rd of September 2020. However, the effect of this notification will be from June 5th, 2020. This approach is aimed at giving firms a breather space so that they can explore options to reorganize internally and bilaterally. In essence, the measures are aimed at securing the continued existence of viable firms in crisis who may be victims of economic circumstances and may be probed to admissible valuations through adversarial actions by the lenders. Key objectives of the Insolvency and Bankruptcy Code 2016. The object clause of the Insolvency and Bankruptcy Code lays down the following key objectives. Number 1, to consolidate and amend the laws relating to the reorganization and insolvency resolution of corporate persons, partnership firms and the individuals. Number 2, to provide for a time-bound insolvency resolution mechanism, and number 3, to ensure maximization of value of the assets. Number 4, to promote entrepreneurship, and number 5, to increase availability of credit. Number 6, to balance the interest of all the stakeholders, including alteration in the order of the priority of payment of government dues, and number 7, to establish an Insolvency and Bankruptcy Board of India as a regulatory body, and number 8, to provide procedure for connected and incidental matters. Next, we move on to principal features of the Insolvency and Bankruptcy Code. For corporate debtors facing insolvency, the code spells out two processes: first, insolvency resolution (CIRP) and second, liquidation. When insolvency is triggered under the IBC, all attempts are made to resolve the insolvency in a time-bound manner. If the attempt fails, the company or the corporate debtor will be liquidated. This is a significant departure from the previous winding up regime, which did not provide for these two-stage time-bound processes. While winding up under the Companies Act 1956 could be triggered by an inability to pay debts, and the rehabilitative process under the Sikh Industrial Companies Act was triggered once the network of the company has eroded. One of the key features of IBC is the early detection of insolvency. Hence, unlike previous regimes, insolvency is triggered under the IBC by a simple payment default of rupees 1 lakh as provided under section 4 of the code. However, the Indian central government is empowered to specify any other minimum default amount higher than 1 lakh rupees, but not more than rupees 1 crore. By exercising this power, the MCA specified 1 crore rupees as the minimum default amount for the purpose of section 4 of the code with effect from 4th of March 2020. This process of insolvency resolution starts with an admission order by the adjudicating authority, that is NCLT. The IBC is a collective mechanism for maximizing the values of a corporate debtor for the benefit of the creditors and all the stakeholders. Hence, it provides a moratorium protection or calm period against individual or collective legal actions against the CD during the corporate insolvency resolution process. Further, the IBC also equips the insolvency professional to apply for avoidance of certain transactions conducted by the CD prior to the insolvency to preserve and increase the pool of the assets available for the collective benefit of the creditors. Next, we move on to the clear-cut definition of what is IBC Code 2016. The IBC is a comprehensive and systematic economic reforms by India that consolidates all existing laws dealing with the insolvency and bankruptcy. This code should be read in conjunction with the relevant rules, regulations, orders, circulars and guidelines by the central government and the Insolvency and Bankruptcy Board of India respectively. It has left procedural and other matters for the central government and the Insolvency and Bankruptcy Board of India. The rationale. What is the rationale? The rationale is to be able to adapt the law quickly in response to the changing conditions. The Insolvency and Bankruptcy Code gives powers to the central government to make rules to carry out the provisions of the code and identify matters for which such rules can be made. For instance, while the Insolvency and Bankruptcy Code provides for initiation of insolvency resolution of a corporate debtor by the creditors or the debtor himself, the Insolvency and Bankruptcy Rules 2016 notified by the central government details the procedure for making an application to the adjudicating authority for such initiation of the corporate insolvency resolution process. The IBC provides power to the Insolvency and Bankruptcy Board of India, the regulator, to make the regulations that are consistent with the code and the rules to carry out the provisions which are mentioned in the Insolvency and Bankruptcy Code 2016. For instance, The Insolvency and Bankruptcy Board of India Regulations 2016 flesh out the provisions for conducting an insolvency resolution process for the corporates. Next, we move on to the 4 pillars of the IBC infrastructure. The first pillar of the IBC institutional infrastructure is insolvency professional, IPs, and IP is one of the most important component of the IBC ecosystem. An IP is a regulated and licensed professional responsible for managing and overseeing the CIRP and or the liquidation process of the CD and the resolution and bankruptcy process for the partnership and individuals. IPs form a crucial pillar on which the entire edifice of the insolvency and bankruptcy process rests. The IBC gives various powers to insolvency professionals while subjecting them also to regulatory and judicial oversight. The first level of the regulatory oversight of an IP is provided by the Insolvency Professional Agency with which the IPs are registered. To support insolvency professionals, the concept of an insolvency professional entity, a regulated service provider supporting IPs, is also recognized. IPs are added in the insolvency resolution, liquidation and bankruptcy process by information utilities, which form the second pillar of the institutional infrastructure. The institutional infrastructures are regulated and licensed repositories of information relating to the corporate data. IUs collect, collate, authenticate and disseminate financial information to be used in the insolvency resolution, liquidation and the bankruptcy proceedings. The judicial oversight of insolvency professionals is provided by an adjudicating authorities, the third pillar of the IBC institutional infrastructure. The adjudicating authorities, which are also known as NCLTs, are specialized tribunals tasked with ensuring that insolvency resolution, liquidation and bankruptcy process is being performed as per the IBC and its related rules and regulation. The fourth pillar is the regulator, the Insolvency and Bankruptcy Board of India, which is termed as IBBI. Next, what is corporate insolvency resolution process actually? Who may initiate corporate insolvency resolution process? We move on to section 6 of the Insolvency and Bankruptcy Code 2016, which provides that where any corporate debtor commits a default, a financial creditor, an operational creditor or the corporate debtor itself may initiate the corporate insolvency resolution process in respect of such corporate debtor. The Insolvency and Bankruptcy Code 2016 defines the expressions financial creditor and the operational creditors. We move on to the definition of a financial creditor and the definition of an operational creditor. Who are those creditors? According to section 5(7), a financial creditor means a person to whom a financial debt is owed and includes a person to whom such debts has been legally assigned or transferred to, and according to section 5(20), an operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. First, initiation of a corporate insolvency resolution process by a financial creditor. A financial creditor, either by itself or jointly with other financial creditor or any other person on behalf of the financial creditor, as may be notified by the central government, may file an application for initiation of the corporate insolvency resolution process against the corporate debtor before the adjudicating authority when a default has occurred. Application for initiation of CIRP shall include record of the default recorded with the information utility or such other record or evidence of default. Name of the resolution professional proposed to act as an interim resolution professional, any other information as may be specified by the board. The adjudicating authority, that is NCLT, shall within 14 days either accept or reject the application filed by the financial creditors. On acceptance of application, the insolvency proceeding will commence from the date of acceptance and the order shall be sent within 7 days to both the financial creditors and the corporate debtors along with the appointment of a proposed resolution professional. Secondly, if there is a rejection of the application by the Honorable NCLT, a notice to the applicant to rectify the defect in his application within 7 days of the receipt of such notice shall be provided. As discussed, initiation of a corporate insolvency resolution process can be done by three entities. One is the financial creditor, the second is the operational creditor, and third is the corporate debtor himself. We have already discussed how the initiation of the corporate insolvency resolution process will be done by a financial creditor. Now we move on to the corporate insolvency resolution process by an operational creditor. An operational creditor may, on the occurrence of a default, has to deliver a demand notice to the unpaid operational debtor, copy of an invoice demanding payment of the amount involved in the default to the corporate debtor in such form and manner as may be prescribed. On default being occurred, the operational creditor shall send a demand notice to the corporate debtors for repayment of the money owed. The corporate debtor shall within 10 days of demand notice either give proof of payment made by it to the creditor or give the existence of dispute against such sum owed in respect of financial creditors. In case the operational creditor after 10 days of demand notice does not receive any payment or notice of dispute from the corporate debtor, shall file an application with the adjudicating authority, that is the NCLT, for initiation of a corporate insolvency resolution process. The adjudicating authority, that is the NCLT, shall within 14 days either accept or reject the application filed by the operational creditors. On rejection of application, a notice to the applicant to rectify the defect in his application within 7 days of receipt of such notice shall be provided. Third, initiation of a corporate insolvency resolution process by a corporate applicant himself. Already discussed corporate insolvency resolution process by a financial creditor. Second, we went to the corporate insolvency resolution process by an operational creditor. Thirdly, we move on to the insolvency resolution process by a corporate applicant himself. Where a corporate debtor has committed a default, a corporate applicant thereof may file an application for initiation of the corporate insolvency resolution process with the adjudicating authority on itself. On the occurrence of default, a corporate applicant may file an application for initiating the corporate insolvency resolution process with the adjudicating authority. What this application for initiation of corporate insolvency resolution process shall include: the information relating to its books of accounts and such other documents for such period as may be specified. The information relating to the resolution professional proposed to be appointed as an interim resolution professional. The special resolution passed by the shareholders of the corporate debtor or the resolution passed by at least 3/4 of the total number of partners of the corporate debtor, as the case may be, approving the filing of the application. The adjudicating authority NCLT shall within 14 days again either accept or reject the application filed by the corporate applicant. On rejection of application, a notice to the applicant to rectify the defect in application within 7 days of the receipt of such notice shall be provided. Next, we move on to which persons are not entitled to make an application for the corporate insolvency resolution. Number A, a corporate debtor undergoing a corporate insolvency resolution process, or B, a corporate debtor having completed corporate insolvency resolution process 12 months preceding the date of making of application. Number C, a corporate debtor or a financial creditor who has violated any terms of the resolution plan which was approved 12 months before the date of making an application under this chapter, or number D, a corporate debtor in respect of which a liquidation order has been already made. Next, moving on to the process of CIRP, there comes an interim resolution professional and moratorium. After a corporate debtor is admitted into the resolution process, a interim resolution professional IRP is appointed by the adjudicating authority, that is the NCLT, as proposed by the financial creditors. The board of directors of the corporate debtors is suspended and the control of the corporate entities affairs is shifted into the hands of the IRP. The IRP shall receive assistance from the existing personnel of the corporate debtor and his term will continue till the appointment of the resolution professional. After the appointment, a public announcement shall be made stating the initiation of the CIRP against the corporate debtor, which would have details such as names and address of the corporate debtor, name of the interim resolution professional and the date on which CIRP would conclude. What this moratorium mean? A moratorium shall be made effective which shall prohibit the transfer of the assets of the company, initiation or continuation of legal proceedings against the corporate debtor or the corporate entity, recovery of any property from the debtor by an owner, the enforcement of any security interest, and the termination or suspension of the supply of essential goods and services. How long this moratorium will continue? The moratorium continues to be in effect as long as the corporate debtor is under the insolvency resolution process. Nevertheless, the moratorium's effect does not extend to key business contracts entered into by the corporate entity or the corporate debtor. Next stage we go to the insolvency resolution process is the verification and analysis of the claim. Once the public announcement has already been made in the two newspapers inviting claims for the corporate debtor, the verification and analysis of the claims will start. During this stage of proceedings, the IRP shall access and evaluate all information on the corporate debtor, including but not limited to the assets and liabilities, business operations, financial and operational payment for the previous 2 years. The IRP shall then view, summon and verify the claims made by the financial creditors and also classify the same. Subsequently, the IRP constitutes a committee of creditors which comprises of all the corporate debtors' financial creditors. In case there are 2 or more financial creditors as a part of the consortium, as it is usually the case with home buyers of a real estate project, each such financial creditor would be part of the COC and their voting share would be determined on the basis of the financial debts owned by them. After the completion of the IRP period, that is for 1 month, appointment of the resolution professional takes place. Within the 7 days of the formation of the COC, which is called as the committee of creditors, the committee shall have to decide by a majority of vote not less than 66%, stating that whether they wish to continue the interim resolution professional, that is IRP, to resolution professional, or they wish to change the IRP by another resolution professional. The committee shall then communicate this decision to the adjudicating authority, that is the NCLT. On appointment of the resolution professional, we shall next move on to the what will be the duties of the resolution professional. The resolution professional shall have the responsibility to protect and preserve the assets of the corporate debtor, which shall also include the continued business operation of the corporate debtor. The resolution professional shall convene and attend all the committee of creditors meeting while also exercising rights for the benefit of the corporate debtor, quasi-judicial, judicial or the arbitration proceedings. In case the committee believes that the resolution professional should be replaced, it can by a vote of 66% of voting shares decided to replace the professional and forward such name to the adjudicating authority, that is the NCLT. In the next stage, the resolution professional will issue a notice or the advertisement in the newspaper inviting bids from the resolution applicants. Now, we go on to the what will be the eligibility of the resolution applicant who will be coming up with their bids to take over this corporate debtor. IBC has been drafted and designed to explore various revival opportunities from an ailing corporate debtor. Therefore, it gives opportunities to an individual, a trust or a corporate bidder, which can be called a resolution applicant, to come forward, invest capital, acquire and purchase the concerned corporate entity which is under CIRP, and also get the company back on the track. Section 29A of the Insolvency and Bankruptcy Code has been enacted various layers of relations to stop the backdoor entry of promoters or those who are connected to the promoter groups of the corporate debtor to acquire the ailing corporate debtor at a discount, a few of which have been explained below. This is vital so that to ensure that the promoters of an ailing real estate company do not acquire the same themselves or via anybody else in the company. Accordingly, an individual, trust, company is not eligible to submit a resolution plan if the same or any other person acting in concert or jointly with such persons or entity is an undischarged insolvent, is a willful defaulter as per the guidelines of the Reserve Bank of India, has an account classified as a non-performing asset, if he is a promoter of a corporate debtor the account of which has been classified as an NPA, is in the management of a corporate entity the account of which is also classified as an NPA, is in control of a corporate debtor the account of which is classified as a non-performing asset. Any such company, its promoters or management which has its account classified as NPA cannot for at least 1 year submit a resolution plan for a corporate debtor under the corporate insolvency resolution process. However, if the same makes the payment of all overdue amounts with the needed interest and other charges relevant to NPA account, the company, its promoters or the management will be eligible to submit a resolution plan. However, the above provision shall not be applicable to a resolution applicant where the same is a financial entity and is a non-related party to the concerned corporate debtor. Next, we move on to the submission and approval of the resolution plan. What happens once the resolution plans have been received by the resolution professional? The resolution professional shall have to examine every resolution plan submitted by the eligible applicants to ensure that the plan provides for the payment of the debts of the corporate debtor in addition to providing for the cost of the corporate insolvency resolution process. The plans shall then be presented to the committee of creditors for their approval. The approval will require a vote of not less than 66% of the voting shares of financial creditors. The resolution plan then be submitted to the adjudicating authority by the resolution professional. The plan must be approved within 180 days from the beginning of the CRP period by the financial creditors. However, the adjudicating authority, that is the NCLT, can extend this period by up to 90 days, which comes to around 270 days. In case a resolution plan is approved within the period mentioned above and is sanctioned by the adjudicating authority, that is the NCLT, the plan would be binding on the corporate debtor and its members, employees, guarantors, creditors and all other stakeholders involved in the resolution plan. However, there might be chances if no plan is approved within the mentioned period, then the adjudicating authority, that is NCLT, is required to order the liquidation of the corporate debtor. After the approval of the same, the committee of the creditors appoints the liquidator to sell off the assets of the debtor and distribute them among the stakeholders. We come to a conclusion. One of the primary objectives of an effective insolvency law is to provide a range of tools to help enterprise address different stages of financial distress. In particular, an insolvency law should aim to restructure viable business and facilitate the exit of non-viable businesses. The IBC also provides such a framework with a time-bound mechanism for restructuring companies through a CIRP or exiting the market through a liquidation process. It has been an important legislative reform that has strengthened India's insolvency regime, helped address non-performing loans and increased overall recovery for creditors. There is also a strong focus to resolve and reorganize the corporate debtor during the CIRP process. The corporate insolvency resolution process is a creditor in control model of restructuring the corporate debtor. This control is exercised through the insolvency resolution professional and later then resolution professional. In a very short time, the IBC has made great strides in providing a predictable framework that aims to provide timely, efficient and impartial resolution of viable businesses and a transparent liquidation process which recognizes existing creditors' right and respect of the priority of the claims. With this, we end the session. Hope you liked the session. Hope you enjoyed the session. I thank you all for the patient listening. Thank you all.